We'll bring you details of that story subsequently. Let's turn our attention to judicial matters now. The Federal High Court sitting in Abuja has stopped the Central Bank of Nigeria from further releasing monthly financial allocations from the Federation account to Rivers State government. Celestina Area has more.
These orders were issued by Justice Joyce Abdulmalik. She held that the presentation of the 2024 budget by Governor Fubara before a 4-member Rivers House of Assembly was an affront to the constitutional provision. She says Governor Fubara's action implementing an unlawful budget, having not been passed by the appropriate House of Assembly, is a gross violation of the Constitution he swore to protect. The judge therefore restrained the CBN, Accountant General of the Federation, Zenith Bank, and Access Bank from further allowing Governor Fubara to access money from the Consolidated Revenue and Federation account. Justice Abdulmalik held that the CBN was under obligation to ensure that the right thing was done before money from Consolidated Revenue and Federation account are released to the beneficiaries. The judge said that the action of a 4-member House of Assembly, which the governor sees as a yardstick to justify an unlawful budget, has since been nullified and set aside by the Federal High Court and the Court of Appeal in Abuja. Appropriation Bill for January to December 2024 being operated by Governor Fubara, having not been charged by the lawful House of Assembly, is illegal, unlawful, and subversion of the Constitution. She insists it is mandatory to present the appropriation bill before the appropriate House of Assembly before legitimate disbursement and withdrawal can be made.
One must commend the court for the time and industry put in this judgment. In spite of all the sentiments, part of all the intimidation, in spite of all the volleys of voices challenging whether the court should go ahead or not, the court delivered this judgment. This is a judgment that touches on the constitutional powers of court and then on the extant provisions of the Constitution. And it's clear there that no money shall be appropriated without an appropriated bill being passed by the House of Assembly. It's very clear from the judgment of Motosho, which was confirmed by the Court of Appeal, that the budget was not properly passed. And in a situation like that, if it's not passed within 6 months, a state is not supposed to collect revenue from a consolidated fund.
The two plaintiffs in the suit are Rivers State House of Assembly and Honorable Martins Amewele. However, the 10 defendants are CBN, Zenith Bank, Access Bank, Accountant General of the Federation, Rivers State Governor, Accountant General of Rivers State Independent Electoral Commission, Justice S.C. Amadi, Chief Judge of Rivers State, Justice Adolphus Enebeli, Chairman of RESEC, and Rivers State Government. Celestina Area, TVC News, Abuja.
Let's now talk to lawyer Bolale Olugbani on this development. What's the implication of this judgment, considering that the Rivers State government still has the right of appeal?
Well, the judgment, first of all, is just legally logical, flowing from the fact that the Constitution says that for there to be an appropriation or a valid sitting of the House of Assembly, which could lead to an appropriation, 1/3 of the members should form a quorum. Minimum members, according to the Constitution, that must the members of the House of Assembly is 24, maximum 40. A fraction of the House of Assembly appropriated, quote and unquote, a budget, 4 members. And the remaining members, who are in the majority, challenged that at the Federal High Court and at the Court of Appeal. So this is just a logical follow-up to the position of the Federal High Court earlier delivered and upheld by the Court of Appeal, that 4 members cannot form the House of Assembly of Rivers State. That budget ought to be represented to a quorum of the House of Assembly of Rivers State. And any expenditure, withdrawal, disbursement, flowing from the 4 members, a fraction of the House of Assembly, is unconstitutional, null and void. And so they have just gone further to consolidate on the position of the Constitution.
The NJC is now looking into what is considered contradicting judgments on the Rivers State matter. Do you see an end in sight legally as regards this impasse?
Well, I think that it will end politically. The legal aspect is being trashed out right now, and at the end of the day, the position of the law will remain the position of the law, which is in support of the provisions of the Constitution of the Federal Republic of Nigeria. Aside from that, I foresee a situation where those who are daggers drawn will have to resolve the matter politically, or one side will lose, that side is the side that the law does not support.
Lawyer Bolale Olugbane, thank you for talking to us on the news.